legal issues for startups and entrepreneurs. So, not going back too far, but most of our presentations are on these are the things you need to do in order to achieve this result as a startup. But this one is, this is how to not achieve a result. So, as opposed to your typical to-do list, this is more of a not to-do list. I broke it down into 11 different things, the themes that I've seen in my 10 years of being an attorney that lead to litigation and expressing it as the opposite in order to avoid being in litigation. So pretty much I've taken great pains to remove any sort of personal identifying information, but pretty much all of these are based, not pretty much, all 11 of these are based in real life litigation scenarios where somebody got this wrong and somebody ended up getting either sued or threatened to get sued. So, and then another thing to emphasize for anybody who's starting a business is the extraordinary cost of litigation. I don't think most people realize how much does it cost, start to finish, to pay lawyers to actually litigate the whole thing. Any guesses? Like we're talking low end. To actually start the litigation to judge or jury decides. I'd say you could probably get away with $100,000, but that's the low end. So the idea is, if you can at all avoid it, you want to. And really, as a startup company, if your revenue is less than, say, $1 million, if you're going to a point where you're litigating something to completion, you're just being completely and totally irrational. So there's steps. If you're thinking sensibly, you should be avoiding this and taking steps to avoid it. And so, about to get started, but before I do, if anybody has any questions, we're obviously a pretty small group here tonight, just feel free to shout out at any point. So you're probably like, okay, I came down to Galvanize the day after Memorial Day, and he's telling me to treat people fairly, like this is some sort of news that I needed him to tell me, but it really does boil down to this so much. The people that get in litigation situations tend to provoke emotion. This gets back to if you have revenue that's below a certain threshold and you're engaging in dispute resolution that is above the amount that's being disputed or in the neighborhood of that, it's gone so far beyond any sort of rational economic decision that you've driven somebody to an extreme point. And there's certain ways to do that. When I was in law school, I did a lot of research on medical malpractice, and one of the most famous studies in medical malpractice, there was these doctors in Harvard who did a lot of research into various medical malpractice events, and they did research on who was being sued relative to who was committing malpractice. And what they determined was it was not the doctors who were committing the malpractice in large numbers that were getting sued. It was the ones with the bad bedside manner. So there was all these doctors that were committing malpractice all over and over again, according to their peers, who were pretty nice about it. And people weren't suing them, and there was all these totally competent doctors who were not committing malpractice, but were making people upset, and whenever something would go wrong, they were getting blamed. So I think there's a lot to be, that same analogy applies to business relationships. The things that go to litigation aren't necessarily the ones where the most egregious legal breaches have occurred. It's where somebody just really pissed somebody off. So try to avoid that. And I think that's pretty important in any sort of negotiation context as well. If you're trying to bleed somebody for every last dollar in negotiation, if you're trying to bleed your co-founder, if you're trying to push every single deal all the way, you're almost certainly going to end up harming yourself down the road. One thing that comes up pretty frequently in a startup context is the vesting schedule. There's the 1 year cliff and the 3 years of vesting afterwards. If somebody leaves the company at 10 months, you're better off negotiating with the person some sort of severance package as opposed to, the contract says this, I can get, if you do that, there's a good chance you're going to end up in litigation. So you're better off, even if the contract says this, if the result is unfair, look at it from the other person's perspective and take a broader view of the negotiation. And it will help your business in the long run. I think this applies to your own choice. I think you should think about this when you're hiring a law firm as well, because certain lawyers pride themselves on bleeding every sort of last deal, that may or may not be in your interest. Because what's in the most lawyers bill by the hour. So it's often in the attorney's interest to get some sort of fight going time and time again, but you're the one driving the ship. Whenever there's any sort of negotiation going on, always make sure that you're the person deciding, okay, I want to come to a resolution here, or at least try to. And not all lawyers will move in that direction. So another thing from the startup perspective that's very important is to really think through these founders' dilemmas from the very beginning. One call I get about every 2 weeks in my business is, hey, I was working on this project with these two people, and we didn't have any agreements in place, and we were going to be business partners, and then they left, and now I want to do the business without them. What do I do? And this person's contributed to the intellectual property of the business, they've left, now there's no agreement, and basically at that point you're in a situation where if you move forward with the business, you are likely to create a situation where once your business is successful, you have the whole Facebook phenomenon where everybody comes out of the woodwork and says, hey, I own part of your business, and you're gonna have to pay them off. So it's very important to confront these issues at the very, very beginning. And whenever there's any sort of sensitive issue, as the Godfather says, Godfather likes to hear bad news right away, you should address bad situations right away. If you let things fester, they get worse. So the sooner you can actually address a mea culpa or whatever the situation is, get to it sooner rather than later. The last point on this, who's read the book The Founder's Dilemma? Which is what the slide is named after. It's a pretty famous book on being in business with other people. But the main conclusion of that business, if you want to say about 700 pages, is that the formalities are more important with friends and family than they are with casual acquaintances. Usually if two people meet at this meetup and decide to go into business together, they'll have a good sense to create some sort of formal relationship, just because you don't really know that person. People are more inclined to go into informal business relationships with family and friends, and usually this leads to the end of the business partnership and the end of the friendship. And that's basically the main conclusion of the book. Also, this book says that because friends and family do not address these issues right away, they're also much less likely, statistically, to be successful. Because they avoid hard issues early on, and people either end up being kind of free riders in the team, and it affects the whole morale of the team, or people don't address issues, and then things end up going wrong. This is one that a lot of people have found out the hard way. And I have one client that's in a situation where I consider this person to be one of the most ethical people I know, but there were arguably some less ethical people that may have been associated with the business, and it brought in other people. So everyone gets involved. Who knows what fiduciary duties are? Well, avoid the lawyers now.
I know, but go ahead.
No,
the responsibility of the officers towards the shareholders and etc.
Yeah. So basically, the idea is that if you're starting a company, there's a good chance that you're an officer, a director, or you're in a position where you are going to be any sort of behavior that happens in the company, regardless of whether you're the one actually engaging in that behavior, is going to be attributable to you. So one of the things that people are usually pretty circumspect about their own behavior, but are oftentimes a lot more forgiving of irrational or reckless or totally unethical behavior from work colleagues. And if you're in a startup, or if you're on the board of a company, you have to assume at any point, if you see anybody doing that, that it's going to be imputed to you. So either purge that person from the entity, or purge yourself. It's just not worth it. And that's law. That's from my civil procedure professor in law school, who told me that when he went to practice law for the first time, he came up with a policy that if anyone was ever going to go to jail for any sort of situation, it wasn't going to be him. So I apply that to all sort of ethical dilemma if there's anybody ever asking me to engage in behavior with which I am the slightest bit uncomfortable, I just, it's not worth it. Like, there's no amount of money that a client could pay you or that you could get from a business transaction that is worth going to jail, that is worth losing all of your assets. And these things, even for business professionals that have been in business for a long time, who knows what RICO is?
Nothing you want to mess with.
Yeah.
It's the racketeering statute for federal charges.
Yeah. So it's the racketeering statute for federal charges, and it used to be only applied to the mafia. That was what it was originally there for. Basically, it was allow the federal government to go after people who it wasn't easy to directly connect them to some sort of illicit organization, but they were able to kind of rope them all in. And plaintiffs' lawyers love RICO. And the reason they love RICO is because of what's called triple damages. Trouble damages. But the idea behind that is that people go on fishing expeditions for anybody in the group. If there's one person that they think might have engaged in unethical behavior, they try to rope everybody in, triple damages, and all of a sudden it gets all sorts of mixed up. So if you multiply any sort of business transaction by 3, and think about that might be attributable to you, that put an extra onus on you to be super accurate.
I have a question. In your experience, when you've seen this sort of reckless, unethical behavior, do you have a sense how much is truly more like a bad apple versus endemic to the organization?
I think I've had pretty good luck in terms of the clients that I've had. That I basically, if somebody's I fire multiple clients as soon as somebody starts making. I didn't go into practice for myself to deal with assholes. She's not in the camera. But as soon as somebody starts to act up, there's no, I won't. So the people that I work with, I think are pretty good people. But I see, I had one situation just not long ago where there was a client that I really think is a very good person, had one of their business partners just snap about something that was totally trivial, and I tried to have a conversation about, really think about where this is going, because if this person is losing their cool to such a degree over such a small issue, what's going to happen when the real stresses of the business come around? Or what if, anybody who's ever run a business for more than, say, 6 months knows that, sometimes it gets really stressful. So when that really happens and you're in the it's a terrible term, like foxhole or something like that, and you're in a really stressful situation with somebody you can't handle basic issues, it's just going to end up being. So in my experience, I'm sure there are organizations out there where there are people that are just.
Well, and sometimes it's just lack of oversight. It's not necessarily like the organization is corrupt, but it's like they're just sort of turning a blind eye, or they're not really.
People are busy.
Checks and balances.
I'm coding. Yeah. You're selling. This person's acting here. A few things here and there. Or there's somebody just overreacts, but you're so busy doing your own thing, and you have your to-do list every day that keeps you so busy that you don't really think, okay, what are the broader consequences of that? But I think if you're dedicating your professional role to it, and it's particularly where you're an owner of a company, or you're director, officer, you have fiduciary duties, and that's something that people aren't as acutely aware of as they should be, I think, in sort.
So is the RICO statute as extensive on the civil side than as the criminal?
So it's civil side stuff. So plaintiffs' lawyers can sue under that.
Okay. So it's as aggressive as criminal, as on the criminal side.
So is RICO's just civil, right? Is it criminal?
Yeah, the mafia.
Yeah. So I've never been involved in a criminal RICO suit, but there are definitely provisions under which they can get monetary damages, which is what I've experienced. So, yeah. I think most of the time, I think the federal government is straining its resources before they're going to be applying a RICO suit to you. You have to be engaged in some serious stuff. But I know, one example of where this has kind of come out is anybody heard of the Atlanta teachers scandal, where they're falsifying tests? Basically, they were helping students. Students had standardized tests, and they were erasing the answers and improving the test scores so that they would get better bonuses and stuff. I'm pretty sure a bunch of teachers were sued under RICO. or there was some action on this civil or criminal, but there was definitely RICO consequences, which is I'm sure bad for them. This probably goes without saying, but I'm going to say it anyways. Never take your personal money and the business's money and mix the two. Never mix the money between multiple businesses. I get more often than I'd like questions about, well, what if I just set up 3 entities, and this entity has the money going to this entity, and this. That always makes me nervous. So people like to have, I had somebody calling me that did not hire me, perhaps because I said that it was a bad idea, coming up with a party bus idea, where basically they had very creative ideas about how to set up a business. And I think that's the idea being, if the idea behind setting up an organizational structure is to avoid some sort of liability, the law is going to see through that every single time. So, if there are legitimate separate operations, set up separate businesses. But if you are just trying to either avoid insurance, avoid the consequences of some sort of liability that your industry might have, avoid. Anyways, and then first of all, what's piercing the corporate veil?
Keep the money separate.
Well, no matter if you've set up a company, they're gonna look into you personally, even if you set that company up to theoretically avoid that. They're get right past
That's
it.
exactly right. So there's a kind of fiction, maybe I shouldn't say it as a corporate lawyer, but there's a fiction that makes a corporation different from a human being. So if you set up an entity, you set up an LLC, if you set up a corporation, the entity is liable for any issues associated with business, the individuals are not. Okay? If you have a situation where you intermingle personal assets and business assets, or if you undercapitalize the business for known risks, so if you know that there is a risk that for example, a good example is a taxi driver. If you're a taxi driver and you have no auto insurance, and you set up a business that way, you are going to have piercing corporate veil issues. And that means they won't just go after the business, they'll go after you in your personal capacity. So all of your assets are at stake. And the one factor that will almost guarantee that courts will pierce the corporate veil is if you intermingle your assets.
So if you do a monthly payout of your profits to your shareholders, is that considered? Okay.
No, so as long as you have a process you follow that's in accordance with corporate law, no issue there. It's when you're just putting money in here and there, there's no process for it. You actually have to have some sort of protocol for how distributions are made.
So, like right now, I'm in the fairly early stages where I'm putting a lot of my own assets or capital into the business, but keeping track of it all, and that's normal.
So particularly with LLCs, with early stage LLCs, I think it's just a matter of, for example, not having business assets, clear business assets being used for personal purposes and vice versa. And then, which, as a single member LLC, it's kind of, that's a very thin line.
We're actually a partnership S corp, so I don't know that it's all that much different at the early stages.
Yeah. So, as long as there's a process and you follow it, you're probably okay. It's when there's clear business assets that are being used for non-business purposes. And then also, a huge fact. So I think I've read that 42% of piercing the corporate veil cases are successful. So it's more common than you might think. One of the things that's very important to have is to have basic organizational documents, and then following those basic organizational documents. So that's a big thing that courts are going to look at. It's like, okay, so what is your operating agreement? What are the rules for your distributions? I don't have it. And there's all these, like, what were these distributions? What were they? It's like, I don't know.
Okay.
And all of a sudden, when you get to like, well, this person's now trying to sue you for $8 million and you never had insurance for that. It all adds up. So when that happens, all the business that becomes real. And that's not what you want. So this is, I deleted this and then I put it back in because this is totally self-serving, but it's also totally true. So I kept it in anyways. So we'll go through it quickly. Basically, you gotta have a legal, some sort of legal budget from the very beginning. I mean, even if it's $1,000, $2,000, even if you're just talking about having an attorney review your basic organizational documents, I think reviewing your basic contracts, the clients that take up, that pay 3/4 of my firm's money are the ones that didn't get stuff done right the first time and end up screwing up and having to fix it later. It's, most lawyers provide very affordable, accessible services for people who are just coming to them and haven't screwed things up yet. Once you screw things up, it gets much more complicated and much more expensive. So the earlier the better. I've been doing this for 2 years, like I said, and in my early meetups, I wanted to be totally down with the open source, like free information, and I was like, no, do it your own yourself, it'll be fine. And now I don't say that anymore because 9 out of 10 people that do it on their own screw it up. So I've just seen so many people get it wrong that I no longer give the advice of do your legal documents yourself. Securities laws. This is really high on the list of things that startups and small businesses just totally ignore. So when do securities laws apply to you? Who knows? Can you guess it?
Can I go public?
Much before that. Whenever anybody invests in your company, securities laws apply to you. So when you are a company and ever you're raising money from somebody, you either have to be a public company, which to become a public company means you're probably paying $2 million in legal fees. So that probably I can apply to most of us. Or you have to qualify for an exemption from securities laws. And then you have to notify state and federal governments of which exemption you qualify under. And that's a fairly simple process if you do it right. So the do it rights are use accredited investors for most businesses, file a Form D with the federal government, and then file within 15 days of raising the capital, and then also file notice filing with the states. And there's usually fairly small $75 to $300 fees associated with state filings. But there's no fee for the federal filing. But most companies get that wrong. So what are the consequences if you don't do that?
Can I clarify that? You're talking now about people who are stockholders.
No, anybody who's investing in your company. So a stockholder, a unit holder, member.
So if you get a loan from your parents and you write it as a loan, you still have
So
to...
as a loan, no. So they would have a... So we could spend a good half an hour talking about security interest, what that definition is. But basically, if they have a right to the future assets of the business, a loan is usually not categorized. A loan is a hybrid, like certain types of loans. So for example, a convertible note would be a security interest. A pure loan, which is 5% interest over time, secured by either unsecured or secured by basic interest, probably not going to be considered a security interest. But most convertible notes, common stock, preferred stock, all that stuff is going to be considered a security. So if you raise money and you don't do that, what's a right of rescission? That's investors can get their money back at any time. So if you raise $300,000 of capital from 6 investors and you didn't file a Form D, or you didn't give any sort of disclosure documents, or you didn't use proper accredited investor certifications, at that point, any of the investors, not at any point, the investors can call you up and say, I want my money back. And they would have a right to all their money back whenever they want. And that's the minimum consequence to that. The consequence will be more serious. And jail's not likely going to happen unless you just go full on Ponzi scheme on people. But more likely, you could get a cease and desist letter. You could get a prohibition from raising further capital. Once you've been found to have violated securities laws, they won't let you do private placements going forward or be associated with private placements. So that means you're basically barred from the startup community, because most startups need to raise capital. So just look into these things within 15 days of raising.
How does crowdfunding factor into this?
I've done entire presentations on crowdfunding too. So the Kickstarter type crowdfunding is what's called donations based. So that's literally just like me giving you $20 and say, I hope you get me something. But if you're actually getting equity in exchange for that, there's a whole complicated set of rules. There's 4 acts under the Jobs Act. and there's all sorts of different complications associated with that. But these same rules would apply, but with crowdfunding, more rules apply. So all this stuff exists with crowdfunding, plus you have to do a closing memorandum, plus you have to do certain legends, plus you have, so there's this plus more for crowdfunding. And then there's a brand new Title IV Act that just came out like a month ago that you have to have full audited financials, so you got to pay accountants $25,000, $30,000 to look at your books, and there's a lot of different stuff. So don't, just because a lot of these websites actually have like platforms out there that are like, look, you can raise money with us, and you basically like think it's like Kickstarter, and you do it, and you just don't do anything. And they're like, in the fine print, all securities law compliance is on you. And you know, I think I've had a number of companies come to me, it's like, well, it's so simple. It's like, yeah, it's simple to do it, but that doesn't mean that the consequence for doing it wrong in your company. This is one of my favorites, and I think that it's one of the most commonly missed ones. And I see it so often, I guess, in early stage businesses that draw up contracts. And this is probably more for people who are kind of more in the small business than the startup world. This is probably more applicable to you because a lot of people print off contracts off the internet. And I would say the majority of them don't actually have basic, appropriate termination language. So basically, sign a contract and we're going to be in business. And there's usually a provision for if somebody breaches one of the terms, then you can get out. But what if you just don't want to be in business with that person? There's a lot of contracts out there that don't have any sort of provision for termination. And I worked with one client that wanted to get out of a contract and had no means to do it. And called up to their site, it's like, you know, I'd like to get out of business with you. They said no. And basically there was provisions for breach. So basically if the person, you know, kicked the newborn baby down the street, then maybe you could cancel the contract. But for any sort of reasonable, it was a very one-sided contract to begin with. And sorry, that was probably perfect, but basically it was an incredibly one-sided contract where there was no reasonable way the company was ever going to breach the contract. So the person was basically stuck in it for life. And the person wanted to get out of it, and they ended up spending probably close to $100,000 in legal fees to get out of a contract. And it was a business that probably didn't make $100,000 a year, or probably was somewhere around there. So it was absolutely devastating. So, you know, they had a 3-page contract they probably either found on the internet or did themselves, but it was really just a very sad thing. And I've seen it, you know, since then, I've probably seen it another dozen times where I've breached in contracts, and from sophisticated lawyers and not sophisticated lawyers. Just people forget to actually have a provision, not just for termination for breach, but for convenience. If, for no reason at all, you just want to leave, you should be able to do that, because business has changed, you might get a better deal, you just might find out you don't want to work with somebody. And there should be provision in every contract you ever had to deal with it. Not too many people have been to multiple meetups, but this is one of the ones that I bring up. I try to bring this up in every meetup just because I just got an email about an hour ago about this very issue with a client. Every person you work with, the intellectual property associated with a startup is really what the startup is. If you don't own your IP, you don't own your share. So every contractor, every founder, every employee should assign the IP to the company. And there's a process for that in exchange for consideration, so something of real value, your equity, or some sort of payment. And people think, oh gosh, I work for a massage company, like that's not going to apply to me. You have somebody do your website, you have somebody do your design, your logo, your trademark, whatever. There are contractors out there that have in their contracts that say, I'll design your website for you, but I'm going to own your website, and I'm going to own all the content. So if you want to go, so they do that, and then they do crappy work, and you want to terminate the contract, guess what? You have to do it from scratch again. I have a client that developed, I have multiple clients that have paid contractors to develop apps, websites, logos, and the contract says the contractor, not the company, gets the rights to that. So the idea is you're paying somebody 20 grand to develop your app, and at the end of the day, the developer owns your app. And it's next to impossible to shake it out at that point. So it's just certainly it's something that comes up in a lot of different circumstances, and it's just something to be cognizant of. So every company should ask for, review it. Another thing to think about is this might not just apply to contracts going forward. Lots of people are under situations where they have assigned their IP not just for their current employment, but they 6 months ago they signed a contract that said for the next 2 years all intellectual property associated with this concept is going to belong to the company that they're working for 6 months ago. I've seen IP assignment agreements that extend 2 years beyond the termination date of employment. So you should ask for, inspect, and then ensure that there are no conflicts with respect to not just present agreements with people moonlighting or whatever, but with prior employers too. And then you should include a provision in the contract that is an indemnification that if the employee misrepresents it, it's on them, not company. So this kind of goes back to what we were saying previously with the fiduciary duties concept, but dealing with an investor is not just much, I got money and now I can go and do what I want. It's a constant relationship. Public companies have entire departments dedicated to investor relations, and even if you're not a public company, which few of us are likely to be, you should definitely, whenever there's a major event happening with the company, you should send a courtesy email to all of your investors. Explain what happened. A founder-elect, an event happened, a good thing happened, there's a new launch, there was a disappointing event. If anybody gives you money to put into your company, you owe a duty to communicate with them, and it's the investors that feel like they were totally left out of the process that are the ones that are going to come out and wait, this happened, and then this happened, and this happened, and I didn't know about any of that stuff. And then you've been asking for more money, and that's what's called a material omission argument, especially if you're going forward. So if you ever have investors, you have to disclose everything, all the sensitive issues with your investors. You have to, like in real estate, you have to disclose any sort of material issues associated with the property or whatever. Similarly, with the company, you have to do the same. So if there's any debt, if there's any negative events associated with the company, if there's any pending lawsuits or a threatened lawsuit, you have to disclose all that stuff. Easiest way to avoid litigation is just not let people see it. And again, for contract to put off the internet, like your typical legal Zoom contract is probably not going to have a mediation or arbitration. I talked to the guy from Uber, who was I think I used to be right here actually, a couple years ago, and asked him like, what percentage of your time is dedicated to legal and regulatory issues? He's like 110%. So, and that was in the early days of Uber.
Makes sense. What they're doing.
Yeah.
They were doing so much stuff.
So, you can't generalize across. If you're, a SaaS startup in a not sensitive area, you should probably think about, just basic formation, contracts, and then maybe some sort of basic insurance, and that's probably better. Can't guarantee it, but you should perform some sort of generic risk assessment of what is my industry and what are, if you're in the health industry, for example, like there's a little bit more costs associated with that. If you are anything that touches anywhere near HIPAA, you better bring out your checkbook to pay lawyers because that's a really big deal. It's tough to. I think for the first year, I think 1,000 to 3,000 is probably a reasonable budget for most startups. And then, year 2, year 3 is just kind of just grow a little bit. I think year 2 might not be too much more for most typical startups. But then once you get into financing, you should probably allocate $2,500 on the low end for even a basic financing. And then, hopefully, you can avoid litigation. I think one of the good things about if you don't have any impending risk with litigation, you can usually deal with that through insurance. And there are insurance specific to patents. There's insurance specific to patents is usually like, I want to say 2% for every $1 million or something like that. So, varies. Any questions?
Awesome question. Are you typically recommending that sort of insurance to cover this?
If you're pre-revenue, probably not, just because if you're so basic in your, again, it depends on the start. Okay, so, for example, I got liability insurance on day one, and if you're a doctor or an accountant, again, in that field, I don't know if the massage liability insurance or
Yeah, I have AMTA.
Yeah.
It's required in the city.
So,
Obviously, the same.
Yeah. Don't cover a lot of these big, and I worked on insurance defense, so, and we represented small companies and large companies that would go through that. The process that would cover most of the major suits, unless someone did something intentional
yeah.
that got them out of their insurance policy.
I think if you once you get, or certainly by Series A, you should have key-person insurance. If not by like a solid C round, you should start considering things like that.
Because I think it can be scary hearing all this and being like, oh my gosh, I'm just gonna get sued. But the good thing is if you do have insurance,
That's
it will
just it.
cover, like they'll pay the legal fees as long as it's covered on your policy. So there is some protection.
I think that's just to be allocation for reasonable expenses, and then having some sort of, I think that combined with basic preventative measures, making sure that certainly your key contracts have been reviewed. I've had people come to me for a variety of vesting schedules and founders documents, and then I'll be having a conversation with them. It's like, just kind of bring up their main business contracts, like, well, how do you do that? It's like, well, I just pulled it off the internet. And they got however much money flowing through based on that one contract. It's like, okay, well, maybe that's the one I got. So that's the kind of thing that sometimes people miss the stuff that's right in front of them. Any other questions? All right, well, thanks for coming. Hopefully we'll see you next one.